All right, I think we are live now. Hello and welcome all the participants of the ECEC 22 conference. On behalf of ETS Group, I'm Elena. I welcome all of you to our breakout session dedicated to the status quo of the transposition of the European Union Whistleblowing Directive in Central and Eastern European countries, where we will discuss the specific focus on Austria and Slovakia. I would like to introduce our great speakers today from the global law firm Taylor Wessing. These are Mr. Martin Eckel, partner and head of compliance team in Austria, and Tomáš Grell, senior associate at Taylor Wessing Bratislava in Slovakia. So I'm handing over a word now to Martin and Tomáš, and we are welcoming you.
Thank you, Elena. Thank you for the nice introduction. Good afternoon to everybody. My name is Martin Eckel. I'm partner of Taylor Wessing, heading the practice area of compliance. I'm based in Vienna. I'm dealing mostly with compliance management systems, and these days, surprisingly, mostly with the question on how to implement and set up a speak-up culture and a whistleblowing system. I will give you a short introduction into the issue and tell you about the implementation, how far we have succeeded in Austria. After that, we will have the possibility for you to ask some questions. And right afterwards, Tomáš is giving you the similar presentation, so you can compare the two systems between Austria and the Slovak Republic on Slovakian law. After that, you also have the possibility for questions. And if we then still have time, we'll try to give you a short introduction into Czech Republic, Poland, and Hungary, where Taylor Wessing is also present. So welcome, please, Tomáš from our office in Slovakia, and give me a second, I will start the presentation.
Yeah, good afternoon, everybody. Just a short introduction from my side. So I'm a senior associate at Taylor Wessing Bratislava, as has already been said, where I focus mostly on employment matters. And in Slovakia, we have been one of the first countries in the European Union to introduce whistleblowing regulation. And until now, it has been very much an employment-related regulation. So I'm really happy to be here today and to share some insights from Slovakia.
Thank you, Tomáš. So we will immediately step in, and at the beginning, let me recall what was the reason for the European Union to come forward with a whistleblowing directive. First of all, and it's very important to mention at the beginning, the right name and the entire name of the whistleblowing directive is the protection of whistleblowers. So it came from the lack of protection for all those people who came forward with reports. What was the reason for that? There had been LuxLeaks. There had been several leaks in the past year, but LuxLeaks was in particular related to German citizens who evaded paying taxes in Germany and therefore removed some of their money to bank accounts in Luxembourg. And therefore the name is LuxLeaks coming from. In the Luxembourg, there had been bank officers, persons working in banks, and also persons working for accounting firms who disclosed that information to the tax authorities back in Germany. And as a consequence thereof, most of the tax evaders from Germany had been chased by tax authorities in Germany and had to pay back taxes and subsequent payments of taxes. That's the good side of the story. The bad side of the story was that those bank officers and accountant persons in Luxembourg who disclosed the information to the tax authorities in Germany had been confronted with trials because they had been in breach of professional and business secrecy. So bank officers and accountant persons are obliged by law not to disclose any information with respect and regard to their clients. And because in breach of that, they had been confronted with trials, and some of them even have been sentenced at court with respect to criminal offenses. And that had been the starting point from the European Union, because at that point they figured out that there is so far no uniform legal framework within Europe. On one hand, some could get a bonus, and others, as we have seen in Luxembourg, can go to trials and get criminally charged. And also, if it's not that dramatic, but some of the whistleblowers are confronted with retaliation in a professional context. Either they are not promoted or they get fired. Some of them have been faced with mobbing of colleagues and even liability claims because of breach of secrecy and similar claims. There had been a liability against them. And that was the reason why the European Union started and came forward with the whistleblower directive, which always had a special focus on how to protect whistleblowers in order to get more insights on infringements of law. Just give me a short summary of who of the 27 member states so far have implemented the directive. For those who are not familiar with legal stuff, directives being passed on the European level need to be transferred into national law, and therefore you normally have a 2 years period time in which time you normally national parliaments pass national laws. And almost none of the member states did that in time. Those countries who already have transformed the directive into national laws are on the bottom line: Croatia, Cyprus, and so on, Denmark, and any further. On the contrary, Hungary has not even started yet coming forward with a draft act or draft bill, and most of the other countries, including Austria and Slovakia, are to say in the middle. We have already a draft in place, which, however, is not passed by our parliaments yet, but which are under discussion of the public. And in the following, I will refer to the Austrian draft, which had been published or came forward by the middle of or beginning of June this year. And the middle of July, there was a deadline of the ministry who asked for statements and comments on the law. There had been several institutions, including, for instance, the Austrian Compliance Officer Association, Transparency International, also the Austrian Bar Association came forward with some proposals and statements as regards the law. One of the very important aspects is the question, what is the scope of the Whistleblowing Act or the whistleblowing law in national law? Before coming to that, I have to explain that on the European level, the European Union and the European Commission is only able to come forward with a directive which is covering those those aspects of law to which the European Union is allowed and has a so-called harmonization competence. For instance, with respect to environmental law, with respect to data protection law, with respect to AML, anti-money law, there is a harmonization competence on European law level. On the contrary, for instance, if you take normal, so to say, criminal law, the European Union and therefore also the Commission does not have the competence to start harmonization. So criminal law is very much different in all 27 member states. And now the question is whether the scope within the directive, which is limited to European law, is supposed to be expanded also to broader national law. So the terminus which is known for that is called gold plating. So if the Austrian or any other national member state is going beyond the scope of the European Union and also, for instance, include national criminal law, that's called gold plating. And why is gold plating that important with respect to the directive? Because it's very much linked to the protection of the whistleblower. So just to give you an example, if a whistleblower is coming forward and is reporting, for instance, an infringement of data protection law in Austria, he is then covered and he is given protection, which means that, for instance, his identity is not supposed to be disclosed and things like that. If the same person is, on the contrary, reporting an infringement of criminal law, let's say a fraud misconduct, then according to the status quo of the act, he is not protected. And that makes it quite difficult for a whistleblower because he has to evaluate on his own whether to come forward and whether he has a protection or whether he has no protection. And therefore this scope is so important to have a look at. And if you have now a look on the Austrian draft act, the Austrian came forward with the proposal that only corruption offenses shall be included in the Austrian law. So if a whistleblower is reporting a bribe, if he's reporting a misconduct in the area of bribery, then he is, according to the draft bill as we have it now at stake, he is protected. If the same whistleblower, for instance, is reporting any fraud misconduct, for the time being, he is not protected. And that seems a sort of weird situation. In particular, if we have a look on a similar draft in Germany. In Germany, all criminal offenses, so the entire criminal act is being covered in the scope of the whistleblowing German law. In Austria, it would not be. So we have, for the time being, very extensive discussion to what extent or whether or not the scope shall be expanded or not. And once again, that's very much linked to the question whether the whistleblower is then protected or not. If I have said that so far there is no final draft in the Parliament. We are waiting actually more or less every single day that it is being published. Once it comes into force and it has been passed in the Austrian Parliament, it is foreseen that there will be a prolonged transitional period of 6 months. So give you an example. Let's assume that it's going to be passed in the middle of October, and it comes into force in the middle of October. Then companies having more than 250 employees still have another 6 months transition period to implement a whistleblowing system, which would then be in the middle of April. If you have a company with more than 50 but beyond 250 employees, you are obliged to implement a whistleblowing system by the end of the year 2023. Now the next thing we will have a look into and it's seen in more detail is the question, first of all, group structure, and the other thing is what the internal reporting officer is obliged to do. Let me start with the corporate question. The corporate question is saying the following. If you have a company having more than 250 employees, you have to implement your own internal channels for whistleblowing. So for instance, if you have a company A in Austria, which has 2 subsidiaries in Austria, both of them having more than 250 employees, all 3 companies will have to implement their own whistleblowing system. However, you can also transfer that to a third party. A third party, for instance, could be an ombudsman or an attorney or even another consultant. And now the question came up whether this third party could also be the group heading company. So company A. So the question was whether company A, which was the group head, is also possible to run and operate and is facilitating the whistleblowing system for the entire group, including B and C, a subsidiary, or whether B and C are supposed to have or run and operate their own system. And this was quite questionable because the answer from the European community and Commission was quite unclear with respect to that question. And so it's very much depending on the national legislator to answer this question. And in Austria, according to the draft bill, which is at stake and which is on the table for the time being, is saying is quite quiet with respect to that. So it's not explicitly prohibiting that, but on the contrary, it's also not explicitly allowing that. So for us as a lawyer, we would say as long as it is not prohibited, it is allowed. So it would be allowed to run a system only within the company A, including B and C. This situation becomes quite tricky if you have these subsidiaries B and C not being located in Austria, but for instance, in Slovakia and in Hungary, because then the question has to be charged according to Slovakian and according to Hungarian law. So therefore, it is quite important if you have group companies with subsidiaries in more than one member state, what the national legislator is advising and stating in his Whistleblowing Act. Another quite interesting question is, a company is supposed to appoint one person who is the so-called reporting officer. That's the person who is in charge of running and operating the whistleblowing system and who is receiving reports and notices from the whistleblower. he is obliged to keep that confidential. And he is obliged to keep that confidential in two ways. First of all, he has to keep confidential the identity of the whistleblower. And secondly, he is also obliged to keep confidential the matter which has been reported by the whistleblower. And even the managing directors of the company is not supposed to know certain circumstances of the reported infringement, but he's only allowed to get to know the circumstances when this is necessary in order to prevent future violations, and only if there is no threat to follow-up measures. So it's a quite unique situation that a reporting officer, that for instance might be a compliance officer, but may also be, for instance, head of HR or whomever a company is appointing as reporting officer, that he has to keep the identity confidential as well as the circumstances of the reported infringement, and which also comes then to the end that he on his own has to decide what to do with the report. Do we have to start, for instance, an internal investigation? Whom else to involve in that investigation? For instance, internal auditor and things like that. Being appointed as a reporting officer is quite a sensible function, and you need to know and have special education to be able to fulfill that function. Another point which always come across is the question whether anonymity is allowed or not. First of all, the Austrian law is saying that there is no obligation to follow anonymous reports. So if somebody is reporting an infringement on an anonymous basis, there is no obligation of the company to follow that report. That's by law. In practice, of course, it doesn't work. Because if you get to know an infringement, even on an anonymous basis, according to your normal obligations, you are obliged to follow that and to start to investigate that. So the question of anonymity or not, even though it's not explicitly regulated in the Austrian draft law, in practice, you would follow them. Another topic we shortly touch before we go to other issues is data protection. And I don't want to talk about things like storage of data and restrict of access of authorities and things like that. But another thing is important to know and consider is the following. According to the GDPR, the Data Protection Act on the European level, those persons who are concerned must be informed. So who is a person being concerned? A whistleblower is reporting an infringement and he's telling that colleague, let's name him A, is involved in a bribe. Then person A is the concerned person, and the concerned person in general, according to data law, has the right to be informed that a report against him has been filed to the reporting officer. And then there is a month time period. Within that month, the concerned persons need to be informed. And now the Austrian Act is dealing under what circumstances there is an exemption from that obligation. For instance, if the direct information of the concerned person would have the risk of hindering and undermining the investigation, then there is an exemption and the concerned person is not to be informed. The European directive foresees a so-called three-tier reporting system. So there is an internal reporting channel to be implemented, and in parallel you have external reporting channels. In Austria, that would be an authority which is appointed in the draft law. That's the BAK, that's the Bundesamt für Korruptionsprävention und Korruptionsbekämpfung. And there are already some other external reporting channels like the Wirtschafts- und Korruptionsstaatsanwaltschaft, which is the public prosecutor for economic criminal law. And I will tell you about other already existing external reporting channels on the last slide then. And only once you have reported either internally or externally, you may report to the public and come forward to the public, and only within a time period of 3 months. So if I'm reporting today and within 3 months I do not get any information back and any feedback back from the reporting officer, I may go to the public and disclose my information vis-a-vis the public. And there are only 2 exemptions to that rule. First, if there is an immediate or obvious threat of the public, for instance, think about environmental infringements, and there might be pollutions which may threaten the public, then you can go forward to the public immediately, or if an authority is involved. And what is shown here on the screen for you as an example is there are in Austria and elsewhere in other member states newspapers which are already offering a so-called Briefkasten, which is where you have the possibility to report on an anonymous basis infringement, and where you also have the possibility with drag and drop to even forward documents to the public. So you can see that also public and medias are already waiting for infringements to be reported. I have mentioned that there are already external whistleblowing systems by several authorities in place in Austria. The most famous one is the so-called public prosecutor of offenses for corruption and economic criminal offenses, in Austrian called WKStA. They have established an anonymous reporting, web-based reporting and whistleblowing system already back in 2012. And you can see here that in the years 2019, 20, and 21, they got more than 13,000 reports being forwarded then. You have to know that not all of them are being related to corruption offenses, because that's the only public prosecutor which is operating and running a system like that. So you have very much reports which are related to, for instance, fraud issues, or are related to embezzlement, or are related to money laundering. And these reports are being then passed on to the relevant other public prosecutors. But you can see out of that there is a tremendous need for reporting, and this channel is being used. On the other hand, if you see the Austrian Federal Competition Authority, BWB, they started back in 2015-16 with setting up a system. There are about not below 100%, 100 cases a year, so 78. But nevertheless, out of these cases, according to the authority, quite half of it, which would be then about 40 cases, are really related to anti-corruption and antitrust infringements. The other well-known authority is the Austrian Financial Market Authority, which almost 300 cases. And the last reporting system had been set up quite recently in the year 2021. That's the city of Vienna. And the city of Vienna, according to publicly available information, also already received almost 200 reports. The only thing is we just can't say whether these are all bribery infringements or overall criminal offenses. It might well be that this overall criminal offenses, but nevertheless, you can see that external systems are in place, external systems are being used, and external systems are being accepted. And therefore, once you consider how to implement your internal reporting and whistleblowing system, always be aware of that you are in competition with these external systems. So if an employee of yours is considering making a report, and he finds on the one hand a very attractive system externally where he can report on an anonymous basis, and on the contrary, he has the possibility to report that in an internal system, but internally, for instance, there is no possibility for an anonymous reporting chance and opportunity, then he, of course, will more likely turn to the external one, and therefore be in mind that these external systems are being well established. Okay, then that's the end of the Austrian part. I will now turn to Slovakia. Elena, happy to discuss if there are any questions.
Thank you very much, Martin, for your great presentation. Dear participants, you are welcome to ask your questions if you have any at the Q&A section of our platform. And I would like to ask maybe at least one question to Martin. So Martin, you were mentioning such an important topic like anonymity of the reporter. So can you please maybe tell a little bit more about practical side of this question? So how do you see this requirement of anonymity in the submitting of reports in practice in Austria within the companies? So tell us a bit more about that, please.
Yeah, as having said, most of the external systems are allowing anonymity and allowing anonymity reporting opportunities, and therefore should also allow that and give the opportunity for the employee to report on an anonymous basis. Yeah, that's very important that you're offering the same sort of quality than external reporting systems. On the contrary, it's very important for you that you not only allow anonymity, but you also allow that persons are coming forward with reporting on a confidential basis. Either they come and have the opportunity to speak with the compliance officer or whom else you have appointed as a reporting officer, and give them the chance. And therefore, it's also important that the employees have the trust that you really keep the information and discussion and reporting strictly confidential. Because if you get to know the whistleblower, then you have the possibility to ask him back. You have the possibility to ask him back questions. You have the possibility to discuss with him the backgrounds and getting feedback. That's something which is sometimes missing with respect to anonymity. But if you, for instance, use a system like the ones being offered by ECEC, there you have also the possibility to get in a chat discussion with a whistleblower, even on an anonymous basis there. But if you get to know, if you get to sit together with the whistleblower, and if you have the trust of your employee, that's of course the best solution.
Wonderful. Thank you so much, Martin. And we have also another question from a guest. The question is, do you think there will be more gold plating in the Austrian law?
Thank you for the question. Yes, we are really believing that and hoping that, but there are already signs from the ministry in charge, that's the Austrian Ministry for Employment and Labor, because of the protection of the whistleblower. That's ministry who is in charge of the law. We have already heard that, for instance, all sorts of HR-related issues will be covered in the Austrian law, and hopefully it will also be expanded to all criminal offenses, as it is for the time being the plan in Germany.
Great, thank you, Martin. Once again, thank you for your presentation and answers. I think we can now move on to the part of Slovakia and to Tomáš.
Well, thank you very much. As I said at the beginning, I very much appreciate that I could be here today, because Slovakia was one of the first countries in the European Union to introduce the regulation on the protection of whistleblowers. So in my presentation today, I would like to talk a little bit about the background or the evolution of the whistleblowing regulation in Slovakia. Then I will try to describe a little bit the existing regulation, and I will also speak about the ways in which this regulation will have to be amended to accommodate the EU Whistleblower-Directive. And in the end, I will also try to share some data as regards the whistleblower protection that we already have from the recent or the period of the past few years in which the whistleblowing regulation in Slovakia was functioning. So if we started with the evolution of whistleblowing regulation in Slovakia, which is actually the previous slide. So it all started back in 2014 in Slovakia. Back then we had a government in power which was involved in a series of corruption scandals. And so there was a huge pressure from non-governmental organization to do something in the fight against corruption. And so against this background, in 2014, the first act on the protection of whistleblowers was enacted and entered into force as of 1st January 2015. Under this act, the whistleblowing agenda was actually assigned to labor inspectorates. And as you can imagine, obviously labor inspectorates, they have many tasks, mainly with respect to monitoring whether employers comply with the provisions of the labor code. So I would say that there was a little bit like a lack of the energy or resources or the expertise that was really needed in order for the regulation to bring the desired effect. So it didn't really work well with the labor inspectorates. And mainly for that reason, a second law was enacted in 2019. It was actually a brand new law, which came into force as of 1st March 2019. And the main change that this law brought was that a new office, a new authority was established, a specialized authority called Whistleblower Protection Office, which actually took over the agenda from labor inspectorates. And this office is only functional as of 1st September last year, because there were some it took a bit more time to appoint the first head of the office. And so currently, as I said, so we have this regulation, but we also need to adapt it to accommodate the EU Whistleblower-Directive. We haven't adopted the amendment yet, but we have a draft which was supposed to be enacted so that it could enter into force as of 1st November this year. But we have a delay because our government currently doesn't have a majority in the parliament, so it's quite difficult to pass legislation. So if we can move on to the next slide, I will discuss a little bit the personal scope and also the material scope of the existing regulation, and also the ways in which it will have to adapt to meet the requirements of the EU Whistleblower-Directive. So as regards personal scope, the whistleblowing regulation in Slovakia has so far only been applicable to reporting persons who are employees or in an employment relationship. So until now, it has really been an employment regulation, but of course, the personal scope will have to be expanded so that we are in line with the EU Whistleblower-Directive. So the personal scope will be expanded in a way that it covers also self-employed persons, shareholders, members of management and supervisory bodies, volunteers, trainees, and other categories of persons that are listed in the directive. Maybe more interesting is to discuss the material scope, because the material scope under the existing regulation actually goes beyond the directive. And in the existing regulation, we currently have basically two categories of breaches to which the regulation should be applicable. On the one hand, there is like a broad category. I would call it like regular breaches. So this is basically any crime, misdemeanor, administrative offense, or other act or omission with negative influence on society, which the reporting person became aware of in a work-related context. Especially this last part, this other act or omission with a negative influence on society, it really leaves room for for interpretation and discussion as to what kind of different conduct can fall under this category. So, for example, we can mention the example of mobbing or bossing at the workplace, where on the one hand, it is definitely a conduct that we as a society don't want to see. And so we can say that it, to some extent, has a negative influence on society, but on the other hand, it's a conduct that usually involves only one individual or victim. So this is something that is really like a borderline case. And so our, for instance, with respect to mobbing and bossing, our office said that this conduct shouldn't be covered by the regulation. It's always really important to ask the question whether it is in the public interest to deal with such conduct or notifications regarding such conduct. And then, on the other hand, we have a special category of serious breaches. A literal translation would be something like serious anti-societal activities. And this includes, for example, crimes damaging financial interests of the European Union, or machinations within public procurement, crimes committed by public officials, corruption, and also any other crime where the upper limit for a sentence in prison is more than 3 years. And also any administration offense where the upper limit in the case of a fine is in the amount of at least 30,000 euros. This is also a little bit problematic because several crimes are not falling under this special category of serious breaches. Most notably, for example, crimes against the environment. But on the other hand, as regards administration offenses, there are really many administration offenses that do not seem to be so serious, but they actually fall into this category because under the respective laws, there could be a fine imposed in the amount exceeding 30,000 euros. So, for example, to give you an example, labor inspectorates basically they can impose a fine in the amount of up to 1,000 euros for any violation of the labor code that the employer has committed. So, for example, if the employer doesn't mention the salary payment date in the employment contract, this is also something that can be considered as an administrative offense falling into this special category of serious breaches, because there is potentially a fine which can be imposed in the amount of up to 1,000 euros, although it will never be imposed in such an amount. That's what the practice says. And also there is really no impact on the employee's rights. So also for this reason, the amendment to the existing regulation, which we are waiting for to be passed, will change the conditions a little bit. Especially with respect to crimes where the threshold as regards imprisonment sentence will be lowered from 3 to 2 years to make it a bit more balanced. If we move on to the third slide, there I would like to discuss a little bit reporting channels, both internal and external reporting channels, and I will also say a little bit about public disclosure. So as far as internal reporting channels are concerned, so currently under the existing regulation in Slovakia, both employers with at least 50 employees, as well as public authorities who have at least 5 employees, have the obligation to establish internal reporting channels, and also they have an obligation to appoint a designated department or person to handle notifications or reports. Following transposition of the EU directive, there will be a small change under which all employers who provide financial services, transport safety services, or services related to environment will have to establish internal reporting channels and appoint the designated person, actually regardless of their headcount, so regardless of how many employees they have. Also, there is the question which Martin was also discussing with respect to Austria, whether an employer may ask an external third party to take care of this agenda in the employer's name. So this is actually possible. So it is possible for an employer to agree with an external third party that the third party will take care of the agenda. This has to be agreed on a contractual basis, so there has to be an agreement concluded between the two entities, and so this way also group reporting system would be possible. But it is important to say that the local employer remains the responsible entity. So if there is any violation which could be committed potentially by the external third party, then it is still the local employer responsible for such a violation, and could possibly claim damages from the external third party. So there is, as far as these external third parties are concerned, those could be law firms or consulting firms or other specialized firms. Currently, one such firm may cooperate with multiple companies and act as a designated person for multiple companies. This will be changed a bit to reflect the EU Whistleblower-Directive, namely if an entity cooperates with a company that has more than 250 employees, such a designated person or external third party will not be able to cooperate with other companies anymore. So this threshold of 250 employees is introduced. As for the designated person, there is an obligation to accept and examine each notification or report within a period of 90 days from its received, and also the obligation follow up and notify the whistleblower of the outcome and also the measures taken, if there were any, within another period of 10 days. What is important to mention is that all those employers with at least 50 employees and the other categories of employers that I mentioned, they also have the obligation to adopt an internal directive by means of which the employer informs employees about the reporting channels and so on. So this is something that we deal with in practice quite often, that we prepare those internal directives for employers. Also, an interesting question is the question of anonymous notifications, whether they should be accepted and dealt with. So the current position in the Slovak Republic is, as far as I know, is that if an anonymous notification or report is submitted internally, the employer has to deal with it and investigate. But in order for the employee to receive protection, his or her identity should be subsequently revealed. As for the external reporting channels, this is a little bit more fragmented in Slovakia currently. Externally, the report can be submitted either to public prosecutor's office or as I mentioned, the whistleblower protection office, and also to administrative or inspection authorities. I can see that we are running out of time, so I think I will skip public disclosure and we'll move on to the next slide to say a few words about special means of protection, because this is something that I believe that is really at the heart of our regulation in Slovakia. I believe that in most countries in the European Union, there is just a general clause saying that retaliatory measures are prohibited, and then obviously the persons who suffer from retaliatory measures, they can go to the court. But in Slovakia, we have two forms of special protection. On the one hand, it is precautionary protection, and this form of protection is applicable to employees who reported serious breaches, which I mentioned on the previous slide. And there, basically, the principle is that if a person receives this form of protection, then his or her employer is not allowed to take any employment action towards this person without prior consent of the whistleblower protection office. So if an employee receives this protection, and for example, the employer wants to deliver this employee a notice of termination, or wants to transfer him or her to another position or something similar, then it has to seek prior consent of the whistleblower protection office, and the employer will receive such consent only if the employer is able to prove that there is no causal link between the notification made and the employment action that the employer is seeking. And then on the other hand, we have so-called subsequent protection, which is basically applicable to all employees who reported other than serious breaches within the material scope of applicable law. And the principle is that if, for example, the employer delivers a notice of termination to the employee and the employee disagrees, the employee may then ask the Whistleblower Protection Office for suspension of such employment action, for example, notice of termination. There is a statutory deadline of 15 days in which the employee should file such a request. And then if the Whistleblower Protection Office suspends such employment action, then, for example, the notice of termination, then the employee stays in the employment relationship and gets paid until the matter is finally resolved before the court. I think we have just reached the 4-hour clock mark. So this is all for me from me with respect to Slovakia. Thank you, and if you have any questions, I will try to answer them.
Thank you very much, Tomáš. It was great, very, very interesting, specific presentation, very interesting situation in Slovakia. I have a question straight away. So I have heard that whistleblowers may receive financial reward from the state under the applicable legislation in Slovakia. Is it like that? And can you maybe relate to that topic a bit?
Yeah, this is also something that is quite specific, I believe, to Slovakia. And yeah, so if employees report one of those serious breaches that I mentioned, so that kind of a special category, they may receive like a financial reward, which is payable by the state. It can be up to 50 times the minimum wage applicable in the respective year. So currently the minimum wage is around 650 euros. So that would make it around 30,000 euros, I believe, the financial reward. Of course, there are certain conditions attached to it, namely that either if a crime was reported, then like an indictment has to be filed with the court by the public prosecutor's office, or if an administrative offense is concerned, then in that case basically a guilty verdict has to be delivered by the respective administrative authority. So those are the key conditions, I would say.
Great. This is very specific case, I would say. So it's very interesting to get to know that. Well, then I think we will finish our presentation then. Thank you so much, Martin and Tomáš, for your great presentations, great speeches. I hope that everybody enjoyed it. And I would like to remind that there will be recordings of our breakout session, and all our participants will be able to review them later on again, to come back to them, and you are free to contact us, to ask for more information from Martin and Tomáš if that was valuable for you, interesting. You're very much welcome to come back to us. Martin, Tomáš, final words to you.
Yeah, thank you, Elena, for hosting and moderating this session. It was a pleasure, and see you the next time. Thank you.
Thank you very much, and yeah, thank you.